Good morning, everyone. Before we begin, I would like to acknowledge that Legal Aid BC's head office is situated on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I would also like to acknowledge that many of you are joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of those lands. Also, as we all know that the province of BC is surrounded by wildfires, our prayers are with everyone who is affected. Our speaker today is from Kamloops. I think she is experiencing them a lot. And as she's joining us today, probably from the hazy skies, our thoughts and prayers are all with every one of you who is affected. So I'm all ready to introduce our wonderful, passionate speaker, Kelly Melnick. Kelly Melnick is a supervising lawyer with the Thompsons Rivers University Community Legal Clinic. Kelly was called to the bar in British Columbia in 2017. She has been with TRU CLC for a year now. And prior to this position, Kelly was in private practice, and she was practicing advanced planning, issues relating to elder law, residential tenancy, family law, and criminal law. Kelly is passionate about access to justice and assisting low-income clients who would otherwise not be able to access legal services. And Kelly's always been generous to us. She's presenting with us from a long time, and I've never heard no from her. So please join me to welcome Kelly Melnick.
Thanks, Baljinder. Every time you do those introductions, I think my head gets bigger and bigger.
Oh,
but all right, enough about me. Let's talk about elder law. It's kind of I think it should be showing. There we go. I think we're there. And I am, like Baljinder said, I am going to keep an eye a little bit on the Q&A. So feel free to pop things in. And I do try to have a little bit of a more interactive sessions if I can, just because then I don't forget about answering somebody's questions, which I try not to do. But I first, before we get too much into it, I'm just going to let, for those participants who don't know about what TRU Community Legal Clinic can do, or the CLC or TRU CLC, as we refer to ourselves, who we are and what we can do. We're located, as Baljinder said, in downtown Kamloops, and we right now are still doing most of our services over the phone, but I suspect that might change in the fall. Students are coming back to campus, so right now everything's by Zoom or by phone, but otherwise we're located just central downtown Kamloops. And so our contact information is there. And I'll just say right at the outset, I will send a PDF of the slides, so those of you that are attending can have a copy. And then that way our contact information is on there. So that'll come afterwards. So really about us, we're the first student staffed free legal clinic in the BC interior. There's LSLAP and the legal clinics down at UVic and UBC. But as far as the interior, we're the first. And how we operate is that the students are law students, usually in their second or third year. And they work under our supervision. So myself and Ted Murray, he is our executive director, but also double duties as a supervising lawyer as well. And we're able to provide legal assistance for a number of different areas. I'll quickly go over those in a minute, but we try to provide as much support and advice as we can for clients that qualify. And so these are people who normally wouldn't have the opportunity to even speak to a lawyer, let alone maybe get some an opinion letter or full representation. So we are really working towards improving access to justice and using the law as a way of social justice. And part of that is us working together with other agencies like Legal Aid or other agencies within the community, Ask Wellness, Interior Community Services, anyone that we can work with to help improve access to justice. And then, the side benefit, of course, is always that the students get to actually develop skills and practice being a lawyer before actually heading out into the big bad world. And hopefully the experience at the clinic will open up their social justice hearts and make them better lawyers in the future, and not fall into any kind of stereotypes, because I think lawyers are awesome if they want to be. So who can use it? It's free service, but they do have to be meeting low income financial eligibility requirements. So we kind of mirror those of legal aid depending on the topic. And so not only do we look at the financial eligibility, we also have to conduct the students to what we call an initial intake interview. And that will also assess the nature and scope of the client's issue. So if it's something that's incredibly complex, unfortunately, because we only have the students for a semester at a time, we can only do so much with that time. And so if it's a highly complex matter that just is something that we can't help with, we'll try and at least give some advice on that issue, and then throw in the most appropriate referrals we can find for that person to try and get them some help. I do note that we've been able to help clients all around the province as a result of COVID, because we have been doing things over the phone. But typically we're restricted to the geographical area of Kamloops and immediate surrounding area. So Ashcroft, Merritt, sometimes Salmon Arm, even Barrier, Cache Creek, Clearwater, in that general vicinity. Anything beyond that, the client's likely only going to get a summary advice letter. And then for us to be able to do a full representation file, so, attending a hearing with them, doing any kind of small claims matters, they have to be able to come to Kamloops, unless we are doing satellite clinics, which during COVID we haven't been. So, So the kinds of things that we do in full representation, anything that involves a hearing, we'll do residential tenancy, employment standards, small claims, human rights claims, and then a limited amount of criminal charges in provincial court only. So those are matters where there's no jail or a risk of jail as far as a sentence. And then they also have to have been denied legal aid. So we're not stepping on any toes in that regard. If we're going to draft something for somebody, we can do some limited assistance, say with a will, as long as the estate's under $25,000 and they don't own any land or condos or no real property, essentially. And that also will apply to powers of attorney in their real property. Involved will be Section 9 representation agreements, advance directives, notices of claim or replies to claims, financial statements for both Supreme and provincial court on family matters. And then we also will assist clients in filing for uncontested desk order divorces. So that's fun. It's a really good opportunity for the students to learn about actual practical skills with drafting things. And these are also things that make it smoother for the court sometimes if it's a litigation file that they've had some assistance in filing those forms. And then we can give summary advice or limited summary advice or information for family law litigation. So they're fighting about the kids or money. We can't help with that. We can give some advice on probate or estate administration, most anything that's within the jurisdiction of a superior court. We don't assist with business and commercial law or real estate or strata matters because that's inherently a lot of money involved. And so it kind of falls outside the mandate of a poverty driven clinic. Personal injury claims, unionized employment, impaired driving or traffic offenses, and complaints against dentists, doctors, or lawyers. So those are things we don't really help with. We might give some summary advice or some limited summary advice, and then refer them out. So that's the clinic in a nutshell. Feel free to send files our way. We love working on the weird and strange, and we're here to help. So if you know people in the interior that need help, let us know. Okay, so elder law. This is my passion area, as Paul Ginger alluded to. I love working on issues that involve seniors, issues that involve capacity. I sit on the board with the Center for Seniors Information here in Kamloops, and elder law is funny. So it's kind of a niche area of law. But what it really does is it interacts with all sorts of areas of law. And so how I'm going to kind of structure this is more of a what is it and how do we do it? It like I said, it's very niche, but I find it fascinating. So it's not just about wills and powers of attorney. Everybody thinks if you're working with the seniors because they need a will or they need their power of attorney, or there's something about going into a care facility, and that's elder law. It's partly yes that, but there's so many more. So we see there's an interaction. There can be interactions with family law. And I'll go into a little bit of detail as how these play out within each in a little bit. But what we see is that it's really any kind of legal issue almost that deals with somebody of an aging in the aging population. And we really, some people don't like the idea of calling it elder law. Some people will call it seniors law. I think the nice term is sometimes aging population, but really at the crux of it, we're dealing with people that are, 65-ish, late, early, mid 60s and up. And they bring, the reason why it's nice to have it as a bit of a specialization is because they bring a different tone. They bring a different mentality to their legal issue. And they're a very vulnerable population that needs a special, in my opinion, a special level of attention to what I call the background noise. And so we're looking at so many different factors of health and social and mental context, and how these different factors actually are affecting themselves, but then also that can affect their legal issue. And so taking all that contextual background and using that to formulate the legal plan to assist them is really what elder law is all about. Because really, there's two kind of the two kind of overarching things. One is, does this person even have capacity? And I mean that's prevalent in all areas of law is whether or not this person has capacity. That's always should be a lawyer's first question. And sometimes it's obvious and sometimes it's not. And then what the background noise is. And so I'll talk about the capacity and then background noise. And then I'm going to go through some specific issues that we see arise quite frequently in elder law files. And then, and as I said, throughout, ask a question, please, if something's just raising for you. So when we talk about capacity, lawyers are under a duty capacity, firstly, to confirm that we think that, yes, this person can instruct us. We can take instructions. And that's always the first question is, can this person tell me what to do as a lawyer? Do they understand what their legal issue is and the consequences of the decision, and are they comprehending the advice? And when we talk about capacity in this session, we're talking about it from a legal assessment. And I know that there is, social workers and nurses and doctors all have their ideas of capacity and how to assess. And that's great. And we can work together with doctors and social workers. And I find in an elder law practice, you really do work quite closely with a client's doctors and social workers, of course, with their consent. But it's really important to understand that there is a difference between their assessment and what we do in the legal profession. So it is a legal assessment of capacity, and there's different types of legal assessments of capacity. And so when we are talking about capacity from this perspective, it's one that's determined by us as the lawyer. And for different issues, we're looking at different levels of capacity. And so that's why I include the sliding scale. So when we're talking about marriage, that's at the lower end. Now, this in 2017, there was a BC case out of Supreme Court that said, well, actually, we have to up the level a little bit of what is required for capacity to get married. And so it used to be like, do you want to get married? Are you drunk? Are you over, 18 or whatever the age was? And then, and you're good to go. If you're not under any kind of impairment, then you should be okay. Now what they're saying is not only do you have to want to do this and enter into the marriage freely, but you should also have an understanding of the consequences of getting married. So that consequence could be as simple as this person would be entitled to, property division under the Family Law Act if you guys are to separate. You both have kids, and if you get married, that affects the estate planning towards your kids. So there's a little bit more of a need now. And then same thing with contract. It's a little bit on the lower end. We're talking about, does this person have the ability to understand what entering into a mortgage would mean for them? But also then what are the impacts or the consequences of entering into a mortgage? Okay, I understand now that my house is subject to this. And if I don't pay, they could repossess the house, or I owe this much money. If I agree to this, then all of a sudden I went from zero mortgage to $150,000 mortgage, and that I didn't really maybe necessarily need, right? And so that is, I'll talk a little bit more about contracts a little bit later, but where you get into these questions of whether or not this aging client has been taken advantage of by a lender, right? And so that's where we have our duty is to really make sure they understand and appreciate what's happening here. And I have seen it happen where, the mortgage provider says, well, let's just register a mortgage in this amount. And they don't have to use the amount. It's like, well, they don't want a mortgage of 500,000. They only wanted to borrow 50,000. So, it's the kind of thing where you have to really think critically and really assess what the client's needs are and what they're telling you they want versus what, this lender is saying. Then we go into representation agreements, and I have Section 7 and Section 9. I had an amazing prof who as some people might consider it slightly callous, but I don't think it is. I think it's a smart way. If you're talking to clients who want to know what the difference is, this is the simplest way from my perspective to remember. So Section 7 is going to be a little less marbles. Section 9 is a little more marbles. So Section 7 is a special. It's kind of like a stopgap representation agreement. I'll go a little bit more detail in those. And it just means that you can't give as much authority, but you can enter into it if your capacity is somewhat in question. And then we move up to the Section 9, and I would put a Section 9 representation agreement and power of attorney almost at the same, because you are giving so much autonomy and decision-making authority away when you do these agreements that you really have to appreciate and understand the nature of what you have. So when we're talking about a power of attorney, what do you have? Who do you owe obligations to? That these people are making decisions on your behalf, and they can do pretty much, under a Section 9 RA and a power of attorney, these people are you for all intent and purpose, right? And so we want to make sure that that we really are assessing from a legal perspective whether or not this person really gets what they're about to do, and that they understand everything about their life and appreciate the impacts that making these documents have. And then, of course, the highest end, we consider this the will, and it's been a standard that has stood the test of time. It was first established way back in 1870 in the UK, and it's really, the courts have considered testamentary autonomy. So your ability to decide what happens to your stuff after you're gone is the utmost importance, subject to a few things. And that's a little bit more of a higher end conversation, or more high level conversation than I think we'll get into today, but it is the highest level of capacity that you're going to need. So that's where we kind of get into that. So I'll talk a little bit more, Dawn, about POAs when I get to it, and we'll get to that in a few minutes, because it is going to depend on the type of power of attorney. So we'll get to that one in a few minutes. So background noise. Background noise is what I term the contextual factors that a client comes to you with. Have they decided to repartner all of a sudden? So there's a new spouse on the scene. And this is much more common now than it used to be. And when I talk about blended families in a couple of slides, you're going to see why this really becomes something to be live to when you're assisting older clients. Are there somewhat similar to Don's question, are children fighting over the care or the home situation, or more importantly, fighting over parents' things? So are there other parties in the background? You know, those first 2 points, who's back here making noise for that could be influencing that person's decision-making? Is there health or social impacts, or are they on any medications? I mean, these are things that can really impact a person's decision-making. Say, for example, they start developing vascular dementia and they start becoming paranoid about their children trying to take all their stuff. And in reality, that's not the case. But there we are. Or if they're on any medications that maybe cause hallucinations or really draw back the adult's decision making, the ability to make rational decisions, right? And so we really want to see what exactly is swirling around in that regard, and then what's the context or the nature of the issue. Has something happened in one of the relationships that all of a sudden now this person's saying, I want to kick this person off my power of attorney. I don't trust them. We've seen situations where, say, somebody is their children's maybe have become Jehovah's Witness. And so when they're appointed as a representative under an RA, are they making healthcare decisions in line with the parents? Are they making decisions in line with their religious views, the child's religious views? So we have to make sure that we really understand what it exactly is that's prompting them to come to you. And maybe it's say in the case of maybe residential tenancy is it that they are being evicted because their tenants or their residential property that they're renting has become run down because they can't maintain the home, and they don't want to move. But you have to have maybe sometimes that hard conversation of maybe it is in your best interest to find a place where you don't have to do yard maintenance. Right. So it's kind of trying to figure out what's the context and what is the way forward for that, and how to fight through that background noise. So if it is, say, like a child that's pushing the adult to move things forward, then we really want to make sure that we're listening to what's happening in the background and trying to pinpoint the influence that's having over the client talking to you. So let's get into the more deep down common issues that we see. And this is where, Don, I'll when I get to the power of attorney, I'll slide over to that answer. Okay. And as everything happens in life, things change and societal standards and norms change. And so that includes divorcing and repartnering. And because it is so much a very common thing, we see that as a problem, not so much in that the blended family is a bad idea. It's more so in that that changes how people do estate planning. And with I find with older clients, they don't look at repartnering as something that should be viewed distinctly than if this was their original partner, and their biological children. So when we are estate planning, our duties are really only owed to a spouse and to biological children. So I have a little note here that children are defined as those that are biological children or children that have been legally adopted by the adults. So stepchildren are not your children legally, right? And so when you have people who are repartnering and each are bringing in their own children, so if you think about it kind of like so you have a spouse A and spouse B, and they have their children together. The duties kind of line up, right? Because you have a duty to each other, but also a common duty to your children. Now, if we have spouse A separated and repartnered with spouse C, and spouse A's kids are over here and spouse C's kids are over here, there is no more common duty to those children, right? So when we're talking about estate planning, if spouse C passes away first and leaves everything to spouse A, which is the normal thing that a lot of spouses do, is leave everything to your spouse. Spouse C's children are kind of over here floating. They've received nothing from parent, and everything parent had entitlement to has gone to spouse A, and spouse A is only their kids here. So children here are floating. And so it really does create a situation in which the spouse C's children have essentially been disinherited, even if that was not the intention of the parties. And I know a lot of people will say, oh, but they'll care for my kids and we promised. There's no obligation, right? So you have to explain to people that plan for the worst, so that if your estate isn't being sued after the fact, right? And so, or to deal with property in a way that sets it up so that nobody's accidentally disinheriting the other's children. And this is where you kind of get this situation where, oh, well, let's just put everything in joint and then we don't have to pay for probate. But that, again, we disinherit kids. So if you have ownership in joint, then we have a situation where nothing goes into the estate because spouse A and spouse C are on title to the house, and spouse C has died. So it just automatically you essentially take off spouse C's, and the right of spouse A is the right of survivorship. They lasted the longest, they get the property. And so the kids, so there's ways to do estate planning in these situations. And even though, well, I just had my old wife on, and that's the traditional mentality is you own everything jointly, you leave everything to your spouse, but that doesn't happen to work out for the children at the end of the day. So we really want to make sure that clients understand these things. So not only that, when we talk about wills variation, in those situations, if things aren't planned properly, there's also these dynamics that blended families have when it comes to health and financial decision-making for the parent when they've lost capacity. Sometimes there is a stepchild that has gotten along and really cared for both, stepdad and mom. And now the stepchild is the biological children of dad as far as the decision maker. And that creates a huge amount of havoc. And it doesn't even have to be with stepchildren. Sometimes blended family or just adult children in general just don't agree on the care plans for mom or dad and really think that they know better than the other parent. And so these family dynamics really can impact how healthcare decisions or care planning or, admission to facilities or, what mom should even be spending money on when they're incapacitated can really create havoc. And really oftentimes the only way to get a straight answer is then having both parties go to court and fight over who thinks mom knows mom better, kind of a scenario, right? So that's really a tricky situation in that regard. And so when we talk about, in Dawn's case, where we have powers of attorney, we have adult children who think they know better than mom and dad. And because they have a power of attorney, they get to make that say. It's not always the case. So an enduring power of attorney becomes effective if this is what this the parent has, if they've not lost capacity, but they've executed an enduring power of attorney, it becomes effective the day that it's signed, right? And it stays effective even after the person has lost capacity, which is why a lot of people like to use those. It does mean that adult children tend to think that they get to say everything and the parent doesn't get a say anymore. That's not true. If somebody has capacity, they still have the ability to manage their legal and financial affairs. So therefore they can and should have a say. And that's what the Power of Attorney Act says. And so when we're dealing with parents, whether, with the adult who's granted the attorney, and we have the adult children stepping in, and whether they're, biological children or adopted child or a stepchild even, when it's enduring power of attorney, is it effective even if the person still has capacity? Yes. But are they meant to take over everything and make all the decisions and manage the money even when the parent still has capacity? No, that's not the intention. That being said, if an adult doesn't like how somebody is managing their affairs, because sometimes people will say, yes, please, because I don't go to the bank anymore, right? And it's just easier, or it's very difficult for me to get around and do certain things for myself. So yes, the power of attorney might make it easier. But in reality, if somebody is not making decisions in the way that you want to do it, that's when there's a conversation to be had with the lawyer about whether or not it would be appropriate to revoke that power of attorney and execute a new one, right? And so that really does get key. So we really need to make sure we understand that older person's capacity and their reasons for decision making. So if the child is overrunning their autonomy, their personal autonomy, and just saying, you don't get to decide anymore, it's all me, well, maybe that person shouldn't be your attorney, right? And so it would be worth the time and money to look at doing something new. And then, we really want to make sure that we're assisting that adult in deciding whether or not a new power of attorney would be appropriate in that case. The other option and this is one that we at the clinic don't do, is it's called a springing power of attorney. And that one only becomes effective on somebody's, like, a determined date. So when I turn 70, if you wanted to do something like that, you can do that. Or typically what people will say is, if I become incapable as deemed by 2 letters of physicians or registered physicians with the BC College or something along that lines. And then you can have it. Those are a little trickier because realistically, who's going to take that person? If you're trying to tell your adult parent that I think you're incapable and I've got to take you to a doctor to get an assessment, not every adult is going to want to agree to that kind of an assessment, right? And so it gets tricky. And that's why an enduring one is typically preferred. I know some law firms, what they will do is they will hold, at the instruction of the adult granting the power of attorney, they will hold that power of attorney, their enduring power of attorney, the original, in their safe. And the only get released is to the adult who granted the authority, so the client, or the person appointed, the primary power of attorney, whoever is appointed, they will release it to that attorney with the doctor's note that says, yeah, no, mom's no longer, there for whatever reason. And that's the only time it gets released. And so that's one way of dealing with it. And so, but yeah, if you're an adult parent and you've appointed your adult child, and now all of a sudden the adult child is telling you, how you're going to live your life, and you're still fully capable, then that's going to be something where you're going to say, okay, maybe I need to do a new one and take this authority away from you because it's gone to your head and I don't like what you're doing, right? So that's going to be a contextual one. And Dawn, when we talk about capacity from the side of a power of attorney, to grant one, to draft and execute a power of attorney, it's the lawyer or notary that's going to do that assessment of whether or not we think this person can sign it. If it's a matter of, this person's lost capacity and now say the springing power of attorney is going to come in, typically it's written into the document. So it would be 2 letters or what have you, prior to coming to the clinic and moving back to Kamloops. So I was in a very small town in Lundy. So it's easy, like, your clients pretty well and their families and kind of know everything that's going on ish. And so it's a little bit easier to live that, to kind of wear out those principles. It can be a little trickier in a bigger community, but for the most part, it's going to depend on what the document says. If it's 2 letters from, and if one of them has to be a psychiatrist or a geriatric psychiatrist, or if it's just a GP that's been treating that adult for however many years, you can make those specifications as to who decides, they no longer can care for themselves legally or financially or personally, in that case, for the representation agreement. So those are really what it's going to come down to. The family doctor could have authority. It really depends, right? And so if a doctor is willing to sign something that says, this person has an aggressive form of Alzheimer's and they are no longer capable, then, that's going to be the question, right? Is whether the doctor is willing to do that. So that's where working with the doctors and the lawyers kind of a nice thing, where the doctors are willing to talk to the lawyer, and then together they kind of do that assessment. But for the most part, it's really going to depend. So in a healthcare context, yes, the doctor would have authority to say they're not able to care for themselves legally or financially. So usually it's like care for themselves or care for their affairs is usually the personal care versus legal financial care. So it really does depend on the scenario. Okay. So undue influence is another that we quite often. And some of the first questions that I always ask is, what is bringing this person in, which we've kind of talked a little bit about, the contextual factors, things like that. And more importantly, when they actually do come in or an appointment is booked, is who is bringing this person in, because we get, quite often we get the child bringing mom in or dad in or whoever in to say, oh yeah, the doctor told us we should start getting the affairs in order, so we're here to get a power of attorney done. Okay, that's nice. And conveniently, it's you being appointed. I don't want to sound very skeptical of generally of people's children, but as soon as someone else is booking the appointment for an older person, who are you? What is the nature of your relationship? And I'm going to pretend I don't like you from the outset. I'm not actually mean to anybody. I just want to make that clear. I'm very nice, but I'm going to be skeptical until I'm proven wrong. And I do that just in an abundance of caution to make sure I am covering all the bases to make sure that this person is not being influenced. And so when we talk about that question of, who's bringing them there, that is when I move to the next point, which is this interview has to be conducted alone. If someone's bringing an older person in for a major transaction like a mortgage or to do a will or to change power of attorney, that person I'm going to want to talk to alone to make sure that I am satisfied as the lawyer taking their signature, that they are totally aware of the contents of whatever the will or the power of attorney or the contract. And again, do they know what the consequences of this decision that they're making really are? And then I'm looking at the power balance between the person and the client, the older person, and whoever's bringing them in, or who they're entering into this contract with, and their reasons why they're doing it. And I want to find out if they're acting on their own free will. And that's really the most important piece is are they acting on their own free will? And is this what they want or what they're being told they should want? And it's very, very common for an older adult to say, well, my doctor and my daughter think that I need this document or this power of attorney and this representation agreement done. Okay, well, do you want it? I always think everybody should have a power of attorney and a representation agreement, just generally in their life, because it's a lot cheaper to do that than apply for a committeeship. Okay, so you want to get it done, and this is a reasonable, rational thing to do. Now, who do you want to do it? And I'll do a little bit of scenario role playing, but where you have this scenario where the son, who is a very responsible person, who's very good with money, is the current power of attorney, and they're coming into you and they're saying, well, my other son, he told me I need to move in with him because I can't care for myself, and now I'm living with him and he's letting me live there rent free, but he says it would be easier if he's the power of attorney. But this son has, debts. He's not the best at managing money. He's gone bankrupt maybe once. All of a sudden, if he's gone bankrupt, he definitely can't be your power of attorney, unless he's been discharged. But the reality is this doesn't sound right. There's something about this decision that I feel as though you as the person taking that interview, you're really wanting to make sure, okay, we've got a son who's been very, hands off and has been letting mom make all of her decisions. And all of a sudden a son who comes in and takes over and is requesting all this, then that's going to raise the red flags all up around me to say, I don't know if this is something we should be doing. And let's talk about all the implications, right? So when we see somebody who's exerting some undue influence against a parent, there is a benefit that person is going to be receiving, right? And we want to make sure that they're not gaining that benefit in a way that is impacting the adult's ability to act freely and independently. And I think it kind of flows into the next one, which is duress and unconscionability. So, for example, is this person, being appointed a caregiver, or are they becoming the caregiver for mom or dad, or becoming the home in which the parent's moving into? And if I don't make this person my power of attorney, they're not going to be able to care for me. Well, that's really going to impact your decision-making and your rationalization. I've seen it where, child A is going to move in with me into my home because it's just easier that way. And I'm going to put them on title. And sure, the other kids, they get it. They understand because this child's going to be caring for me. Well, now all of a sudden you've disinherited your other kids and you're giving that child basically free reign. As soon as you put somebody on joint, whether it's a bank account or on a house, they have control. They have an element of control over your asset, over your bank account. And so it's the kind of thing that you don't want to go into lightly, and you don't want to let your clients go into lightly. They really have to understand that doing what the implications of, say, joint ownership will create, which is that right of the other person to get the whole thing when you die. So when we're looking at somebody, when they start talking in a way that makes you think they're not doing this for themselves, they're doing this for someone else, and it's creating a very unfair benefit. And it takes away that autonomy that we were talking about, that personal ability to make decisions for oneself. And as soon as we look at the context of, well, now all of a sudden child A is very conveniently, I'm on joint now, let's get a mortgage, it's one of those things where these kinds of things line up, where we're seeing a benefit to the other person. And there's that power imbalance. And usually with seniors, it really evolves around, you kind of find guilt a little bit will fall into that, with maybe one of the children isn't doing so great and convinces mom to let me do this and come on title, or add me to your bank account, I'll help with your bills. And all of a sudden there's this benefit that's going to another child, or the easiness. I hear that a lot. It's just going to be easier if I just, then they don't have to do probate, or then they can just deal with it. And I don't have to worry about making, getting to the bank or making these decisions. When the reality is you really have to make sure, that you're looking at that background relationship. And if there's a power imbalance, and there's the other one that's a really strong example is these predatory marriages, where you have seniors who the older person meets somebody quite a bit younger. And maybe that's in the context of a care relationship, which doesn't happen very often, but has happened. And there's court cases, sadly, about these things. And, the one partner has nothing and a huge amount of debt. And now it's that friend. This has been a friend of mine for so long. You see that quite a bit, where it's a companionship relationship and they call it a friendship. But if you actually go through and look at the nature of the relationship, they might become spouses. It's not always about marriage, right? A spouse doesn't have to be married. They just have to be living in a marriage-like relationship for more than 2 years. And sometimes people enter into these companionships because they just don't want to be alone. And I think we all can understand and appreciate that. But sometimes there are untoward purposes. And so we have to be very sure that we understand the true nature of, say, this relationship with this new friend that has moved in and is a roommate, but we share bills and we share meals and we go on vacations and we go to outings. And, to the outside viewer, it really does start to look like a marriage-like relationship. And so we have to really be sure that we see that whoever's coming into the person's life is getting a very unfair benefit, or wields a certain level of power imbalance, then we have to make sure that we're paying attention to the influence and the idea of unfair benefits that arise out of that relationship for the older adult. So when we talk about unconscionability, that again is where we have, say, a mortgage provider who is encouraging. I think you've all probably heard or seen these reverse mortgage scenarios, that the adult is, being put in a position where they feel they have no other choice but to agree to this mortgage. And the transaction really doesn't make sense for the adult, other than I don't want to move out of my house, and so this is the only way I can stay in my house. Well, that mortgage provider is really going to be getting an unfair benefit. And so our job is to try and make sure that person does get the independent legal advice that they really truly need in that scenario. And it does hurt sometimes to have to be the person to say, look, like, this is what's going to happen. If we register this mortgage for $250,000, and it's this reverse mortgage, and you start using that money, at the end of the day, you're going to have a huge mortgage against your house. And is that what you truly want? Or, is there an alternative scenario, or say in the case of a residential tenancy matter of, if this person is living in a way that they really can't care for themselves, and the properties become too much, but they don't want to get evicted, ultimately, they really ought to be in a place that is more of an assisted care facility, you kind of have to have that conversation and say, is it actually a bad thing? And so that's kind of going to lead me into this next one, which is it a bad decision? It's not our job to police the client's decisions, right? And so all throughout elder law, it's personal autonomy. Generally in the law, this is an important thing, very important thing, but especially in elder law, I feel that making decisions for the adult is not what our job is. Our job is to make sure that what they are doing is hopefully in their best interest. That they have all the advice and information that they need to make their decision. But again, at the end of the day, it's going to be their decision. And so clients make bad decisions all the time. Sometimes you don't agree with it. But it doesn't always mean that it's going to be an invalid or an illegal decision. So that type of a decision is like an invalid or an illegal decision is one that doesn't accord with law. So I've got a little example where I say, I'm going to sell to my kids, so it is not considered my asset anymore. Now, on the face of it, doesn't necessarily seem like that's an illegal decision. But when you probe a little bit, if you find out it's because they can't, they might have done something that there's a court action coming. Say, for example, they got into an accident when they shouldn't have been driving and they didn't have insurance. That house is one of their main assets, and that would satisfy potentially a court judgment against them. You can't sell, you can't transfer the home into your kid's name so that the court can't take it, or they can't force you to sell the house to satisfy a court judgment, which is kind of a convoluted thing to do. But the purpose behind it is to hide the asset. That's illegal. That's considered a fraudulent conveyance. And so that's not permissible by the law. So that would be something that I would have to say, sorry, I can't do this for you. But you don't know unless you kind of probe and get through some of that background, right? And so if it's more a matter of, I want to put my child on title for the home because I don't want to have to pay probate fees on the value of the house. And my friend's husband died and she wasn't on title, and it was this whole big thing to get the house into her name because she wasn't on title and she had to pay tax and this and that. And so I think it's just better if I put my kids on title. I'm going to say, I don't think it's the best decision. I don't think you end up giving up control. And if you're going to do that, then maybe we have to consider drafting a life estate and agreement and all sorts of things. And my job is to, inform the client of why I don't necessarily agree with this. But if you want to do it, are the things you're going to need to do. If you don't do these things, I don't think you should do it. And I might not do it if you don't do these things. And I'm just saying I won't do it, but it doesn't mean you couldn't do it. That's our role, right? So what are the pros and cons? And then let them decide don't do if we don't agree with it. And I hope that kind of makes sense. Bad decisions happen all the time. I don't always agree with clients, but it is their life, right? When it comes to working with seniors, I think that it's almost a matter of considering, okay, so we're going to help this senior with the decision that they've got to make that's legal. Who is their support network? Who else can I, is this client okay with me talking to, are they okay with talking to their kids? Or if they have a care aide or if they have a social worker that's assisting them, can I talk to that person to get a little bit more background? Because sometimes it can be difficult to get the full story out of older clients. They forget things, or they don't necessarily think it's important because it wasn't important in their mind. And so sometimes you do need to talk to a couple people that are involved in their life. Do they have any substitute decision makers? So if we're talking about a legal decision and we've kind of thought about whether or not this person has capacity, and maybe we're on the fence, do they have a power of attorney, someone that is appointed to make decisions on their behalf, and that we can talk to? And then what the issue that they're actually coming to you with? Are we dealing with the housing issue? Are we dealing with a change to an advanced planning document? A family member or maybe a doctor is telling them that they need to do something. What exactly is it that they have? And I think underlying all of those is there a background issue, right? Is there an issue that, maybe they have an issue with housing, and their issue they come to you with is more so that they're getting, again, it's a very easy one for us because we deal with this quite regularly. Are they being evicted? But is the underlying issue that they just cannot live on their own any further? And if that's the case, then the eviction, we can try and help with, and we can apply to dispute it, and go through that process with the residential tenancy branch. But the underlying issue is, does this person actually need to be somewhere where they have access to care aides 24/7, or somebody that comes and checks on them every day, something like that can actually help with the problem? And then, do they have any conditions that impact how you can serve them? Do they have hearing issues? Do they have a cognitive impairment? That's usually the most common consideration. But sometimes, it's a matter of the fact that it's not that they understand, that they legitimately cannot hear you, and sometimes too, it's also, with certain clients, and I don't think this is an age specific one. There are some people that are a little bit more legally savvy than others. And so it's also just a comprehension thing. And so sometimes, and then this is something we work quite extensively with our students on, is learning how to get out of the frame of mind of speaking in legalese, right? And using highly technical terms for something that this person might seem like they don't have capacity because they're not understanding what you're saying to them. But it's not a matter of them actually understanding the issue or the document. It's a matter of what you're spitting back at them. And so really simplifying major, and sometimes not even major, just legal terms that aren't in common use language, right? And then, of course, mobility issues, and that's a big one. Sometimes you have to go to their house. Sometimes they have issues getting up in the building. Is your office, say they have to come in a wheelchair, is your office wide enough to accommodate the wheelchair? Things like that. So you really have to think about these things when you're working with an aging population, and they have to really formulate whether or not, is your office set up in that senior friendly manner, right? Easy to get to, easy to move in and out of, comfortable, bright enough. If you rely heavily on technology, that might set you up for failure working with seniors. Some are very tech savvy. I'm not going to say they're not. I see it a lot at the Center for Seniors Information. It's not a matter that there are those. I know my dad is finally learning how to use an iPad, which, my 5-year-old nephew can do whatever. He's better at it than I am. But, my dad is in his late 60s and he's getting there. So, you have to adjust your style to them. And that, I think, is probably the most important thing. And making sure, you have to book enough time for an appointment with the senior. And it's, I have found it's not a matter of sometimes the thing is that they talk slower, or sometimes it just takes a while to get the story out. It's fine. And I'll even point to criminal matters where when you're dealing with seniors on the stand, it can be it can be difficult. And I think that some people have a very hard time. I have patience is key. I'm going to jump right to that one. Patience is key. You have to really take the time to let them tell you everything that they think is important. And even on the stand, sometimes you ask a question and the story veers and goes all over the place. And then eventually, 15, 20 minutes later, we're about to get to the actual answer, right? And then also when we're talking about time too, we also want to think about, so if this is an older client, are they better in the morning or are they an afternoon person? Are they more so? Yes, absolutely. Do they look sleepy? When you have an appointment with a client and you're dealing with, serious legal matters, it is overwhelming, and it can be a lot of information thrown at them. And so sometimes maybe it's a matter of booking 2 appointments to go over what you can normally do in one with somebody, right? So if you are looking to fill out CPP or OAS or CPD forms, sometimes you might have to just accept that you're going to take a little bit more time, and that is what it is. And so that also too is, training your staff on how to interact with seniors. With older clients, it is very tricky sometimes, right? Like, so we want to make sure that we're dealing with seniors in a way that is respectful, and that our staff are understanding. I know here, our office manager, she usually is the one that books the appointments. And so typically if there is a child booking the appointment for mom or dad, that gets flagged right away. And so we know that our staff and students are aware that, if a third party is involved, the flag goes up. Or, for some of the students, one of the questions, depending on the client, if they're doing, say, a will interview, we book about an hour for our first interview for wills or powers of attorney, because we've developed a really lengthy questionnaire to try and get as much information as we possibly can. Sorry, there's I think the military helicopter is just going over right now. The issue we really want to get them to understand is if you think that your client might not have capacity because they're really just getting flustered and not answering the questions really well, maybe you should ask the client next time, like when you go back in, because the students will check in with us, ask this person if they're more a morning person or an afternoon person, because they might have just got slotted in at the wrong time. We don't typically deal with if capacity is at issue. The students, because of the complexity that arises with those types of files, is we do end up having to close them immediately, because students aren't qualified, in our opinion, to deal with clients that have capacity at issue. And so it's a matter of, okay, so if you're out in private practice or for advocates out there that are dealing with clients that maybe have a dementia diagnosis, or if sundowners is a real thing for that client, then we have to make sure we understand that, and a note's put on a file saying, don't book this person at this time, because it's just not going to get anywhere. Right. And so we really want to be able to understand how to interact and how to book appointments and how to deal with clients. And then also understanding their traditional ways of thinking and how those traditional ways of thinking can differ from the law. That's how things used to be, say, with putting everything in joint ownership, versus how things are now. And so having that conversation with the client can be very difficult. They don't want to do things different than they believe they should be. And again, this goes back to the bad decision versus a legal decision, or, one that you can't in good conscience do. And then that's where it becomes an unconscionable transaction, right? It just because you get married to this new person, or you start living with this new person, that doesn't mean you have to give them everything in your will. Right. There's ways to do it, and you really should be considering those things when you talk to the lawyer about your advanced planning, if it's a new spouse scenario or a blended family scenario. Or if, say, you are repartnering and your new partner wants you to sign a marriage agreement because they're bringing a lot of stuff into the relationship and you're not, well, you really do need to get independent legal advice to make sure that whatever this marriage agreement says, you've never had to do this before, and so you don't think you should have to. Well, maybe it is a good idea if you do have some things. So this is where, as a lawyer, you're going to have to come in and say, okay, these are the pros and cons, and then help them along with that decision. But I find with elder law, oftentimes, well, I don't understand why I can't just do it. This is the way my last lawyer did it. That comes up. The law has changed in 20 years or 25 years or sometimes 30 years since you last did a will. So we have to really make sure that it fits with the way the law works now, right? And so making sure that they understand how those things really work hand in hand is going to be really important. And so I find when you're working in an elder law and when you're serving an aging population, not only making sure that your office is senior friendly, but also just understanding their way of thinking can really make a big difference. But overall, we're looking at that background noise more than anything, in my opinion, to really make sure we're serving that population, working with those older adults in a way that is respectful of their own personal autonomy and decision-making abilities, but also making sure that we're not letting them get themselves into situations where there's the potential for abuse or undue influence or duress, where we've got we're letting them enter into a contract that they really ought not to be, because they feel they have no other choice. So really, at the end of the day, I think our role is almost like a gatekeeper. Again, they're allowed to make bad decisions. We all make bad decisions. But when we're dealing with older clients, we really are trying to make sure we understand where they're coming from, what's happening in the background. And is this decision going to be in their best interest? And then from there, we kind of go through the decision-making process with them to try and help make sure that they are going to make the best decision for themselves. And if they choose not to, we've done our best. So, that's elder law in a nutshell. I think I'm not sure if I went a little over time or if I'm a little under time, but we've got room for questions.
You have lots of room for questions.
Oh, perfect.
Pretty good. Yeah. And anybody, please ask questions. Kelly have time to answer questions. So please feel free to ask any questions at this time.
Otherwise, I can fill in a little bit of, Adult Guardianship Act and committeeship.
Yeah, that'll be nice too. You have about 20 minutes.
Okay.
Yeah.
Okay. So just a couple things that I didn't quite, I wasn't sure how fast I was going to be moving through this. So one of the things that is not in here is talking about with the advanced planning documents, we have representation agreements and powers of attorney and wills. What happens if somebody doesn't have a power of attorney or a representation agreement? What is the choice left for that adult? And that really is the committeeship application. And that's where you're having to go to court to be appointed as a committee of that adult. And you basically are having the court say this person is incompetent and they're not going to become competent in the future. So now you are the legally appointed guardian of that adult. And so that gets tricky. So that's committeeships. And so those are quite a bit more. I always, when I was in private practice, I always said, look, it's way more expensive to do that than it is to do your power of attorney and a representation agreement. Because if you're looking at going into Supreme Court, you need 2 affidavits from 2 doctors. You have a lawyer going to petition the court. And then you also have to have the public guardian and trustee involved. And that gets very expensive very quickly. And in the smoothest run committeeship applications, you're still looking at, for 3, 4, maybe even 5 months. And in contested ones, you're looking at, 6 to a year before the committeeship is appointed. And during that whole time, there is no one for the adult. So it's better to have something in place than not at all. And then you also have to think about when you're serving an older population, if your red flags are going up, who are your resources to call to take over an investigation into that issue. And so there's a couple that you can go to, and I'll throw those into the chat. Is there any? Yeah. So there are some, there's some agencies that might be able to assist. So I'm not sure if Kelowna out in Kelowna does it, or if the Penticton Access Center, I think. I'm not sure if their services include necessarily wills. I think Access Pro Bono, they do have a wills program. And so Access Pro Bono in the Lower Mainland could probably help in that regard. As far as in most in the interior, I think we might be one of the only ones that does it for free. However, you can contact the lawyer referral service. Let me just see what I can do here. Just going to quickly pull up a couple phone numbers here. So the lawyer referral service, through Access Pro Bono, they do. I know, and it's one of those things where it is really unfortunate. I do get asked often if legal aid does wills and stuff, and unfortunately they don't. But that's kind of the sad part. But that's okay. Someday.
Kelly.
See, there you go. If anyone, yes, next Thursday, 10 a.m. Yeah, and then this is the phone number for the lawyer referral service. And sometimes you can get a lawyer that will potentially take you on pro bono as well. So the Wills Clinic, they might be able to, is it Dustin that's presenting on that, Baljinder?
There are a bunch of, it's a panel from Access Pro Bono. We have Heather. I believe Dustin is in there. But
okay, great.
Not Dustin, Mona and Aaron.
Oh, okay. Yeah. Yeah, because I think Dustin's more doing chambers now. Maybe. I'm not 100%. But yeah, so I think that there are some programs, there has to be a little bit of digging. I know we can, in the future, hopefully when COVID's over, we'll be going to more of the interior communities, like more remote communities. And I'm not sure if Kelowna does. I don't think they do. I don't think they do powers of attorney, unfortunately. It is. So I'll say this about powers of attorney. Powers of attorney are very interesting in that you don't necessarily need a lawyer or a notary to witness it, as long as you have 2 people witnessing that are over 19 and are capable themselves, and also not the attorneys being appointed. And so the frustrating thing is that while that is the case, that you can do your power of attorney without a lawyer or a notary, I have found that it is more so the banks that won't accept them. Sadly, it's the banks that kind of put a brake on whether or not you can use that power of attorney. So the law allows for it, but the banks themselves typically don't. Now, I'm not saying this is all banks for sure, but there is, it's been my experience that the banks usually create a bit of the holdup. So that's usually that. And also they have their own powers of attorney. I don't know if any of you have ever dealt with that, but I get my backup when I find out that clients have executed a power of attorney with a lawyer or a notary and have gone to the bank, and the bank said, we don't want that. You can do ours. It's really frustrating, in my opinion, because I don't understand how they have it's just frustrating. That's a side issue, in my opinion. But it is a really frustrating because, you do take the time and spend the money to get done properly with a lawyer or a notary, and all of a sudden it's not being utilized for its intended purpose. So it's very frustrating in that regard. But I'm not a bank. I don't get to make that decision. I just know that that's been referred back to me. Or, It's interesting. Are they? I don't know, because I don't know. I've not seen them. I don't know how they execute them. I don't know if it's two witnesses that they get signing it. I have no idea, Dawn, and it's the most infuriating thing because I've not seen one myself. I've never been asked to fill out one for my own bank account. I don't understand. And I find certain banks in certain cities, because I practice in a couple areas now, that it's like each individual one is its own thing. I don't know. I've even had it when working on probate issues with clients where we're assisting the applicant for probate, so the executor or the administrator who's applying, and we're saying, okay, so we get through the process of getting all the forms into the courthouse, and the courthouse is ready to issue the grant. They just need the probate fees. And so you take your paper to the bank, and the bank says, yeah, we're not issuing you any money until you're appointed. And now you're stuck in this back and forth with the bank, because the bank is saying you can't have money unless you have unless you have the grant, but you can't get the grant from the court unless they get the money. And I actually had to work with the registrar on a file. So the court, the head of the court, Vernon, and the court registry operations, and she had to get on the phone with the bank and say, come on, we won't get this unless you give them money. And if you don't give us the money, then they're not going to get the grant, and we're just going to keep going in circles. And so eventually they did. But I've also had other clients where they ended up having to get a line of credit taken out so they could pay the probate fees and then pay themselves back once the grant was issued, and they had control over the bank accounts again. And it's absolutely infuriating. I think, if you tell a client, look, go talk to the bank and find out which one, if I get a power of attorney, or do you have one internal? In both cases, honestly, I think it is still important to have a power of attorney, because it's not just the financial side of it with the bank. It's also the legal, any legal decisions and yes, financial. So, for example, if part of it is, I need to be able to access the bank accounts, and the bank won't let you because they want you to sign their own power of attorney. But part of accessing the bank accounts is because you need to sell the house because parent has been moved into a care facility and you need the funds to help pay for their care. You need the proper power of attorney so that you can register it with the land title office. And there's magic words with the land title office. There's a specific clause that in our powers of attorney, we specifically remove, since we're not dealing with, we don't do anything that deals with real estate. So we take that specific clause out of our powers of attorney and make clear to people, like, if you buy land after you've executed this, you need to get a new one, and we can't do it. There are resources for blended family style wills. So it's often, Yeah, I can see how it would be a question that's often in wills workshops. It really is going to be so factually specific to that blended family. In some cases, it's a matter of putting the property rather than in joint tenancy, so that it blends, so it goes to the survivor. You do what's called tenants in common, and then that means that spouse A owns chunk, half, and spouse C owns half, and then you grant a life estate to each other, so that if one dies first, this person is allowed to stay until they either can't live on their own anymore, they choose to sell, or they pass away, and then it's divided out in the estates, right? So you have control over your half to your kids, but it's subject to the other person moving or dying. So that's one way you can do it. Some people will do trusts. That gets very complicated, and that's usually mostly necessary for higher value estates. But most of the clients we're dealing with, sometimes what you can do is you would do it's like a mutual will agreement, and there's not really too many resources, really. It's because it is so unique to the family. But sometimes what people will do is they'll just include a statutory declaration with their will. Oh, Alessia? I see your hand up.
Hi, Kelly.
Yep.
We have one of our participants. Her hand is up from quite a while, so we can answer her question.
Oh, okay, sure.
Okay. My question is apparently on the subject of capacity to decide or to instruct, that apparently the only legal remedy is through a POA, right? Am I right in understanding that?
So if we're looking for capacity to take instructions as a lawyer from a client, is that what you mean?
Yeah, and at the same time to decide on certain matters, like you showed that the high and the lows, where you started with marriage, and then which is the lowest, and the highest is the will. Actually, my question is actually about what are the other legal remedy that a senior can have aside from a power of attorney? Is there any other legal remedy for that?
So if someone has capacity, the decision is always going to be theirs to make, right? Okay. If there's some question about whether they have capacity, sometimes that's going to take a little bit more probing by the lawyer. Maybe they'll want to talk to the doctor or the social worker, and it's going to be very fact specific. And so one of the funny things about, and this is, I think, what drives most doctors and social workers crazy when I say this, is that, look, sometimes a person, and this is important to find out if they're a morning person or an afternoon person, or if they have sundowners, is that you want to explain that person has to have capacity in that moment when they're signing. So if somebody does have, say, capacity issues, and we hit them on the right day, and I'm satisfied they are coming to me with free, on their own free will, they understand what I'm talking to them about, the day is right, the year is right, they know everybody's names. They say, yes, I want my daughter to make that decision. I can take that signature that day. And then the next day they might not have capacity. Right. Yeah. And so that's kind of the fun, scary, sad thing about working with an elder population, is that it can be a roller coaster as far as capacity. Right.
Yeah.
So if they have the power of attorney and they're on the down and they're no longer able to make decisions, then their power of attorney is going to make their legal, financial, and then their representative is going to make their medical and personal decisions. If they don't have either of those, and they're on the down and they're not coming back up, then then that's when we look at applying to be a committee and going through having somebody appointed as their legal guardian. And hopefully they have a family member that can do it. Otherwise, it might be left to the public guardian and trustee. One of the things you can have done is if for some reason your power of attorney, like it'd be really rare, but this would be like preparing for the absolute worst case scenario is if you say you're two spouses and you appoint each other as your attorneys, something happens to your spouse and they can't act, and your backup is one of your children, and for whatever reason they've been in a car accident and they're in a coma, they can't act, and you have no one else in your power of attorney. What you could have done is made a nomination of committee. So it would be, look, if for whatever reason none of these people can act for me, and somebody has to be appointed through this process, and I'm declared incapable, never coming back, this is the person I would like it to be. And not a lot of people do that nomination, because usually the power of attorney is sufficient. But if you're worried that maybe one or both of your attorneys, or some people will appoint 3 people in a power of attorney, that's one way of controlling a little bit of control, like maintaining that little bit of control over who would make the decisions. But realistically, at that point, you're not even part of the decision-making process, because you just mentally cannot be. And so that's where your power of attorney and your representative are supposed to, according to the Power of Attorney Act and the Representation Agreements Act, those people are supposed to be acting in your best interest with what they know to be your values and beliefs. So whenever I have a client in who's making a power of attorney or representation agreement, I go over that section of the Power of Attorney Act that says, look, you got to do this, you got to do this, keep your records, keep notes on your decision making, always involve mom and dad as long as they can possibly be involved in that decision making process. And as soon as they no longer can, you have to still make your decisions with what you know to be their beliefs and values. And so for me, it's very important not just to be very frank and, kind of almost, I always joke it's a very morbid area of law sometimes when you're doing this stuff, but you are killing people off and saying, okay, now who makes the decision? And now who makes the decision for you, right? But really what you're wanting to imprint upon your senior clients is, look, you're still here. These decisions will impact you. So pick a person, make the authority such that you're comfortable with it. And my job is to make sure that when they come in to sign and I witness their signature, they know that they're supposed to be acting within the confines of the act, but also your instructions. So if you have made it clear, look, I never want to be put in a care home, and don't ever move me to the island. I don't like the rain. And you're appointing a child who then now says, well, I want to move to Victoria, so you're coming with me. It's like, well, now you're acting outside the interests and the wishes of your parent. And so that's where you're going to get into trouble. So don't do it. Right. And so that's the kind of conversation I like to have, not just with the parent or the older adult, but also with the person that they're appointing. If I scare the bejesus out of an appointee, then I've done my job, right? Make it very clear to them that there are eyes. There's the public guardian and trustee, and there's other people out there that are watching their decision making to make sure that they know that if they are going to be using this authority, that there are people out there watching, and that there are rules to how they have to act. Like, for example, in the act, it says that if you have, in the Power of Attorney Act, if you have committed an offense against against the adult you're acting for, that one's pretty obvious. If you say, for example, have assaulted mom or dad, your authority as power of attorney is gone. If you've committed or if you've gone bankrupt, your authority gone. If you can't handle your money, we're not trusting you with other people's money. And one that people don't often get, and I think this is an important one, is if you have appointed your spouse and you and your spouse separate, and sometimes it's an involuntary separation. So sometimes you see one of the partners is moved into a full care facility. They're no longer living together. And so they divorce because it's just, too hard or whatever. That spouse that still, has moved on. It's not to say they don't love their partner that's in the full care facility, but you know what I mean? As soon as you separate and you divorce, your authority as attorney ends, unless your power of attorney is very specific and says it can continue even if you separate. So it's really important that seniors understand, like, look, if you're thinking about divorce, you're going to need to update your power of attorney because that person's authority is going to end. But realistically, the decision-making ability is either going to go to an attorney or a committee. Yeah.
Okay. Thank you so much.
No problem, Letty.
Yeah. Thank you, Kelly. That was a very good and deep explanation. I think there's a lot to elder law, and I'm sure participants have learned a lot. There's lots of confusing concepts in there as well. Mm-hmm. If you agree, we can run this session again, maybe in 2 months of time or something.
Sure.
Because it looks like, elder law also, it's a lot to do with wills and estates.
Yeah.
Maybe we can have 2 presenters, one on the wills and estates side and one on elder law side.
Sure.
Yeah. So you and me can talk more about it and we can see what can we do.
You bet.
Yeah. So if you have any other questions, please feel free to ask at this time. I think it looks good, Kelly. Thank you so much. It was a lot of information, a lot of wonderful information, and you presented it very well. Oh. Thank you so much. Thank you to all the participants. Thank you to everybody, Sarah, Alessia, Kelly.
Thank you, everyone.
Have a wonderful evening. Wonderful
You too.
afternoon. Yeah. Thank you.
Bye.
Bye-bye.